All right, so today I wanted to discuss the second part of the Epstein files and the Ghislaine Maxwell case. The Ghislaine Maxwell interview from the FBI from July 24th and 25th of this year. And she hit on a point in the first part of the interview in the audio files, which I will attach, and the redacted PDF, which I will read. She touched on the CVRA case, which it was 2008. It was essentially Courtney Wild, at the time, who was a 14-year-old girl, against Epstein, who at the time her name was undisclosed because of her age. So I'm going to read from page 37 really quick from the Ghislaine Maxwell file, and then I'm going to kind of go through a timeline and try to piece it together a little bit. And also I have some documentation from the DOJ and from the Supreme Court, which has some interesting material in it. So like I said, I just want to preface and disclaimer that I'm not a professional, not a lawyer, no background, completely discredited, just doing this because I'm bored, have nothing else to do. All right, so this is just an opinion piece, doesn't mean anything, most likely not true, most likely false, very incorrect, very half thought through. All right, so that being said, page 37, Ghislaine Maxwell. So this timeline, just for reference early on, this is during the timeline that she says that basically they don't see each other, they don't really hang out anymore because it's 2001-ish to 2003. So during that time, she says that Taj Blanche, the interviewer, says you don't have a relationship with him at that time. She says, well, I did see him. This is Ghislaine Maxwell, quoted from the PDF. I maybe saw him once or twice, maybe even 3 times. I certainly went to his house once for sure, maybe twice, but I was not seeing him. The only time that I was in touch with him was when things happened. Things like, in the press that affected me, or when the CVRA case was filed. And there was like rubbish that went out because I needed information. This is her words. Because I didn't know anything about what was happening, and I needed his help. Well, that doesn't sound right. Let me rephrase that. I don't mean his help. I meant to have answers so that I had an ability to defend myself. That's what I'm talking about. I'm not taking anything. And then she stops. So the CVRA case, I wasn't really sure what it was. It was in 2005 it started. It was with basically they were investigating Epstein at the time in Palm Beach for, like I said, the accused of Courtney Wild allegedly doing sexual acts or whatever the allegations were at the time against him. So during 2005, that was what was going on. And at that time, Ghislaine Maxwell stated that she was in a relationship with Todd Waite, like I said, the Gateway Computer co-founder. So I didn't really remember the CVRA case. In 2008, I was in college. I was pretty young. I wasn't really paying attention to this type of thing. So I looked into it just because I was curious. Like I said, this is around the 5-minute mark. And so essentially, this is what I found. This is going to be a timeline of what happened, okay? Well, actually, let's establish first what the CVRA even means. All right, so let's go by that. So this is from the Supreme Court Docket 21-351. So this is the Courtney Wild, the petitioner versus the United States District Court for the Southern District of Florida. And this is right out of the background information. So in 2004, Congress enacted the Scott Campbell, Stephanie Roper, Wendy Preston, Louarna Gillis, and Nila Lynn Crime Victims Act Right. So CVRA stands for Crime Victims Act Right, commonly known as CVRA. The CVRA includes 6 subsections addressing crime victims' rights, the manner in which victims may assert those rights, and the role of the federal court and prosecutors in protecting those rights. At the times relevant here, subsection A set forth the following rights of crime victims. So I'm going to read a little bit into the CVRA subsections of the statute. So there are 6 subsections, A, B, C through F. All right, but under this that I'm going to read, there's 8 rights in subsection A. And this is a crucial point because this plays into the plea deal later accepted by Epstein. So number 1, the right to be reasonably protected from the accused. So in this case, the protection would have been from Courtney Wild against the accused, Jeffrey Epstein. All right. Number 2, The right to reasonably accurate and timely notice, the right to reasonable, accurate, and timely notice of any public court proceedings or any parole proceedings involving the crime or any release or escape of the accused. Number 3, the right not to be excluded from any such public court proceeding unless the court, after receiving clear and convincing evidence, determines that testimony by the victim would be materially altered if the victim heard other testimony at that proceeding. Number 4, the right to be reasonably heard at any public proceeding in the district court involving release, plea, sentencing, or any parole proceeding. Number 5, the reasonable right to confer with the attorney for the government in the case. Number 6, the right to full and timely restitution as provided by law. Number 7, the right to proceedings free from unreasonable delay. The right to be treated with fairness and with respect from the victim's dignity and privacy. Number 8, the right to be treated with fairness and with respect for the victim's dignity and privacy. So the key factors here that played a role in this case specifically is number 3 and number 4. So number 3, I'm just going to read it back because it is important. The right not to be excluded from any such public court proceeding. So in this case, the non-prosecution agreement, NPA, was what Jeffrey Epstein exercised during the trial. And the problem with that is he was not prosecuted because it was a state level procedural judicial process, is what I'm going to state. So because it was at a state level, not federal, that's where it gets a little ethically challenged, or like I said, there was a lot of backlash later because of this, because it was not at the federal level, it was at the state level. And that plays a role in the right to basically exercise the Criminal Rights Act, the protection. So number 3, like I said, the right to not be excluded from any such public court proceeding unless the court, after receiving clear and convincing evidence, determines the testimony by the victim would be materially altered if the victim heard the testimony at that proceeding. So what happened was the NPA, non-prosecution agreement, was done kind of behind closed doors. It was a closed doors activity, and the problem is that Courtney Wild was not aware of the plea deal until basically it was all done and completed, more or less. There was no documentation presented to her people. There was no reactionary time on her end that she could be involved with the plea deal or try to fight it. So that's where this gets a little, like I said, ethically challenged and where the backlash happened. So that was, like I said, the 8 subsections of that Rights of Crime Victims Act, basically the CVRA Crime Victims' Right Act. So that's important because, like I said, during the timeline, at that time, it started in 2004, as I stated in that write-up. That's when that actually became a thing. It wasn't anything before 2004 where they had protection, the petitioners. So now they have protection, and then, like I said, in 2005, the year later, Epstein gets, basically there's the allegations against him, and he gets investigated. So it was a pretty rapid turnaround time, so I don't think it was handled appropriately, in my view. Because of timing. Like I said, it was a new thing. It was kind of not handled the best way systematically, in my opinion. But like I said, just my opinion doesn't mean anything. So for, like I said, historical preference, in 2005, they investigate Epstein. The victims have no CVRA rights yet on the pre-federal charges because it's at the state level. So if it was the federal level, where his indictment happened in 2019, was at the federal level. So if it wasn't the federal level, it would have been done it probably would have been more seamless in the court system. But since it was a state level, it wasn't really executed appropriately at that time because of the level change between the state and the federal levels. All right. So in 2007, the federal prosecutors began the secret plea deal negotiations with Epstein. So the CVRA rights would attach only if federal charges were filed. So as stated prior, there was no federal charges at the time. There's only state level charges through the Courtney Wild case in Florida because it happened in Florida, West Palm Beach area. So in mid-March 2007, the victims received generic letters from prosecutors. So the CVRA right to confer with the prosecutor, right to be heard, state law, some notification would have been inputted. But like I said, that was at the federal level, not at the state level. So unfortunately, like I said, there really was no coverage for her. And like I said, there was backlash later. But like I said, that was in 2019 and the charges were different. So it wasn't the same charges. It was Courtney Wild was a specific charge from 2005 to the conclusion in 2008 where Jeffrey Epstein had the NPA, the non-prosecution agreement, which is why he was only It was a plea deal, which basically reduced his sentence down to 13 months in jail, in county jail, and then largely free after that, up until the new allegations in whatever it was, 2017 or whatever the years were. I don't have it in front of me right now. But what I want to emphasize here, too, is that being said, so Epstein walked after 13 months. He was in jail for 13 months. He accepted the plea deal, and it was handled how it was handled. And then there was the backlash later for the Courtney Wild case. But so what I want to emphasize here, too, is that I looked into the DOJ, the justice, and I have these links. I'll attach them. So if you want to do your own research, which I'd highly advise because I'm sure I missed everything. But what I did notice, there were specific differences between the justice.gov website and the Supreme Court website regarding the same case. So this is where, to me, it gets interesting. And like I said, there is a difference between the DOJ and the Supreme Court, obviously. But what I thought was interesting was the Supreme Court differences that I'm going to bring up and I'll emphasize were actually referenced in the Supreme Court section directly to the federal indictment in 2019. So I find this interesting. So I'm going to read the DOJ first, and then I'll go through the Supreme Court file. Okay. Hopefully you guys are completely bored out of your mind by now. Here we go. So justice.gov website. As set forth herein, over the course of many years, Jeffrey Epstein, the defendant, sexually exploited and abused dozens. I want you to emphasize and focus on that word. Sexually exploited and abused dozens of minor girls at his time in Manhattan, New York, Palm Beach, Florida, among other locations. And also I want you to emphasize coming up the years that I'm going to focus on here. In particular, from at least in or about 2002 up to and including at least 2005. So I want to focus on those words because words matter when it comes to basically allegations, accusing, and any sort of prosecution. Like the words, these are transcript words. So they are very, like I said, they have high status in anything that happens legally. So emphasis on dozens of minor girls, and then also the years, at least or about 2002, and including at least or about 2005. All right, just remember those words. So now this is the Supreme Court docket, which the Supreme Court docket is 21-351, the Courtney Wild case. And this references the indictment that I just read from the justice. Like literally it says, I think it's July 2nd, 2019, SDNY indictment. So that's literally the indictment that I just read from. But here's the words, right? The words are different, which is weird. Doesn't make sense to me. Like I said, maybe I just don't know anything about legal. Fine. So it says between 1999 and 2007, which, as referenced before, like I said, if this is a direct reference to the justice file, the justice file says 2002 through 2005. So there's a 6-year gap, right, between 1999 and 2007 on the Supreme Court side and on the justice side in or about 2002 and up to at least or about 2005. Seems a little weird. It's not specific, whereas the Supreme Court is specific. It says between 1999 and 2007. There's a start end date. There's no guessing. There's no in or about. The verbiage is weird, okay? Not saying it means anything. Not saying it's right or wrong. Just saying as a reference from the Supreme Court side to that document, it's weird that the numbers don't match for years. It doesn't match at all, right? So, and also these words, in quotes, mind you. This is in quotes on the Supreme Court docket. Epstein, so quote, Epstein and multiple co-conspirators sexually abused more than 30 young girls, including the petitioner, Courtney Wild. I put the Courtney Wild in there. The petitioner is still in the quotes. In Palm Beach, Florida, and elsewhere in the United States and abroad. So that is the weirdest thing ever because, like I said, it's literally pulling from the justice system file, but the justice system file does not say that. In quotes, it says dozens, which, like I said, for me is an emphasis on less than, right? When you think of dozen, what comes to your mind? Dozen is 12, right? 12, the number 12. So dozens meaning 2, right, would be 24. Okay, fine. So dozens, so say specifically 24 is less than 30. So like I said, I don't know what the emphasis is. I just know that the verbiage is weird that it says dozens when the Supreme Court says in quotes 30 young girls and the years specifically 1999 to 2007. So like I said, just weird verbiage, weird play, but like I said, it doesn't make sense in my mind. But what do I know? Like I said, I'm a nobody, don't matter, just op-ed here, okay? So I'm also going to read the factual background from the petitioner, from the file from the Supreme Court. So this is the Supreme Court file, which references, like I said, the actual justice file that I read from. All right. So the factual background: petitioner is one of many women who were, as minors, victimized by notorious sex trafficker and child abuser Jeffrey Epstein. See indictment, United States versus Epstein, 19 CR 490, which is what I just read. STNY, July 5th, 2019, SDNY indictment, which, like I said, that's the DOJ, that's the justice file that I read. Literally, this is referencing that at the Supreme Court, all right? Between 1999 and 2007, quote, Epstein and multiple co-conspirators sexually abused more than 30 young girls, including petitioner in Palm Beach, Florida, and elsewhere in the United States and abroad. See the indictment that I just read, and I will attach. Epstein came to the attention of law enforcement in 2005 when the parents of 14-year-old girl, a.k.a. Courtney Wild, informed Palm Beach police that Epstein had paid her for a massage. Like I said, this is the file. This is not my words. This is the file. Office of Professional Responsibility, Department of Justice Executive Summary of Report Investigation into the U.S. Attorney's Office for the Southern District of Florida resolution of its 2006 through 2008 federal criminal investigation of Jeffrey Epstein and its interactions with the victim during the investigation. Let's see. So this is still the file. Investigation led to discovery that Epstein used personal assistants to recruit girls and provide massage to him. In many instances, those massages led to sexual activity. End quote. Let's see. What else do I want to cover? Let me read this real quick. Okay, so this is important to the CVRA. So, all right. So on July 19th, 2006, for felony solicitation of prosecution, that was the charges. Because the police chief and lead detective in Palm Beach, quote, were dissatisfied with the state attorney's handling of the case and believed that the state grand jury's charge did not address the totality of Epstein's conduct, they referred the matter to the Federal Business of Investigation, the FBI, for a possible federal investigation. So like I said, so this is just important because of the timeline. And I also want to emphasize that in 2008, when the plea deal went through for Epstein, the non-prosecution agreement, which means obviously he can't get prosecuted at the state level, and he took the plea deal, served a lesser sentence, right? But I also want to emphasize that timing is everything, right? And I'm not saying it was orchestrated or any conspiracy nonsense, but I am saying that in 2008 also, right after that, because this was, what was the date here? Give me one second. I'm sorry. I have so many notes. So I think the prosecution date was July of 2008. But so for emphasis here, the housing crisis was also happening in 2008. So people were losing their homes. The economy was totally tanked. Fannie Mae was the first to go. Then the Lehman Brothers filed for bankruptcy. AIG had to be bailed out. So there's a lot of things going on. And I'm not saying that that has anything to do with the Epstein case, but I am saying as far as the public backlash at the time, plus with the CVRA just being a new enactment in 2004, I think the backlash wasn't what it would have been, especially in today's world, because, obviously technology wasn't what it was back then, as well as, like I said, you had the whole economy was in shambles due to the housing crisis, and then you had the Epstein thing, which was kind of on the back burner because of that. So like I said, not making excuses for it, but I am saying there is a little bit of a timeline here as well. So to the result of the Courtney Wild case was that she was fighting it up until 2019. She basically tried to prosecute and go after him again, basically stating that they mishandled the case and that the CVRA should have been enacted. The Crime Victims' Right Act should have been enacted. But like I said, it was at the state level. They went to the federal level, and then he ended up getting the allegations against him again in 2019 and being indicted. And then he ended up dying like a month later. So in essence, that case died with him because now he's not, prosecution cannot happen on a dead person. So there's that. But anyway, I just thought mostly what I was trying to accomplish with this is that I thought that it was interesting the DOJ file was different from the Supreme Court, even though the Supreme Court file literally references the DOJ file. But somehow the release that we see had different years and a different number, dozens instead of 30. Like I said, doesn't mean it's a big deal. To me, it means something, but like I said, doesn't mean it's right. Doesn't mean it means anything to anyone else. All right. But anyway, so that's just a touch base on the Ghislaine Maxwell file about the CVRA. I'm going to try to get more into it. Like I said, I've been a little distracted with other things, but I'm going to try to get more into it and kind of keep going, and we'll see how it goes. All right, but thank you for your time. I hope you enjoyed it. Hopefully it at least enlightened you, or like I said, encouraged you to read it for yourself. Have a wonderful day.